I'd like to welcome you to this edition of Law Solicitors Legal Updates as we speak again about immigration today. It is an honor to be presenting this program on a weekly basis every Wednesday. So I hope you can all hear me. Today is warm weather here in the UK, and I just thought to present while sitting outside in the warm weather in the UK today. So we just want to continue with our legal updates on immigration. And if any of you guys have got any questions, I'll gladly answer all the questions as much as I can, so that I should be able to assist you as much as I can. If not, you can then either email me or contact me on the contact details that appear on the screen. My name is Andrew Nyamayaro. I'm a solicitor at Law Solicitors, and at our firm we do various areas of law, including immigration, employment, civil litigation. We are also commissioners of oath. So I think just wanted to do a presentation on the various topics that are always topical in the area of immigration. I'm just maybe waiting for our numbers to increase a little bit, and then I can start on the few topics that I have, and I'll also get questions from you guys. I'm just hoping the door is a bit warm today. So the first topic that I want to present on is the topic of bringing children to the United Kingdom in a situation whereby the parent is on a limited leave to remain on the basis of private life or family life. I have in mind a situation whereby one of the parents he has been given discretionary leave to remain because they have got children with a British citizen or someone who's got indefinite to leave to remain. Under those circumstances, normally that person with the discretionary leave to remain does not have an automatic right to bring dependents to the United Kingdom unless if there is exceptional circumstances or there is exceptional grounds, exceptional and compassionate grounds why that person can bring a child or a dependent to the United Kingdom. So if that person is a single person, we have to prove that there is exceptional and compassionate circumstances which can allow that person to bring over their dependents to the United Kingdom. If the dependent is a child, we might want to know the circumstances in which the child is living or staying in the country where they are currently resident before they come to the United Kingdom. So it could be proved by getting, for example, an independent social worker's report, a letter from the doctors or from the school or family and friends who are looking after the child in that country. We can also prove that by producing evidence from any professional people who are involved in the life of that child. And it is also important to get the voice of the young person to be heard under the circumstances, so they can also write maybe their own statement, which can then be put as part of the evidence to be submitted to the Home Office. If the parent is married or staying with someone who has got British citizen or who has got indefinite leave to remain, then I always think that it is best for the partner or the husband or the spouse, the wife, to become the sponsor of the child as a relative of um, that particular child, and then prove the relationship through evidence and that the sponsor is married to or is in a relationship, a long-term relationship with the partner. If unmarried, a period of 2.5 years is a period that the Home Office normally consider as a durable and subsisting relationship between the two. So, in that particular circumstance, you might rely on 297, Immigration Rules 297, paragraph F, where the person, the spouse, the sponsor, is a person who is a British citizen or indefinite leave to remain in the United Kingdom. Whilst on that topic, someone is also saying that, can I bring over my grandchild? Bringing over your grandchild, and I'm assuming that your grandchild is someone who is under the age of 18, again, would also depend on the circumstances. If you have the closest relationship or relation to that particular child, then you could potentially bring the child to the United Kingdom, assuming that the father or the mother do not have capacity to look after that child, or they've passed on, or they cannot be located, their whereabouts, then as the grandparent, you might be able to bring over the child as a relative. Uh, Sometimes it might be advisable to go to the guardianship court and obtain guardian of the particular child. If with a guardian order, you can also then submit it with part of the evidence to show that you now have legal rights over that particular child. So we are speaking about bringing a child over to the United Kingdom in a situation whereby the natural parent of that child has got discretionary leave to remain, which is normally 2.5 years, issued normally on human rights grounds, such as a family or a private life. And that visa normally comes with conditions that you cannot invite a dependent to come and stay in the United Kingdom until you get your indefinite leave to remain. Until we are discussing ways of going around that requirement, which includes having your partner or spouse inviting the child to the United Kingdom on your behalf, or having to prove to the Home Office that there is compassionate and exceptional circumstances that are existing, so that you can be able to bring over the child if you are a single parent, without someone who can support the child in terms of being a spouse or a partner. Um, Compassionate circumstances might be that there is no one who can stay with the child. The people who have been staying with the child, they have left the country where they are staying, or they are deceased, or for another reasons such as medical, they cannot continue to look after the child. So you can try to put such arguments in the application, where you have got a spouse who's British or who's got indefinite leave to remain. You can use them as your sponsor, and as a close relative to the child. And then you produce your marriage certificate or evidence of cohabitation if you're not married for at least 2 years. Maybe you might be having other children in the United Kingdom who might be British children, so you might need to produce their birth certificates or passports, supporting letters, letters from the doctors, from the school, from the imam or the pastor, letters or affidavits from or statutory declarations from the people who are staying with the children, why they cannot continue to stay with the particular children. So that is how you can try to go around a situation whereby you use discretionary leave to remain, and you cannot you want to bring your dependent children to the United Kingdom around the requirement that you cannot bring them unless there is compassionate and exceptional circumstances in what is normally called the discretionary leave to remain. Okay. I am a mother of four. I have one back in Nigeria and three here in Manchester. Me and my ex-husband are here, but our first daughter is in Nigeria, and I'm a British citizen, and my ex has got indefinite leave to remain. Now we are thinking of our daughter to come and live with us here and her sisters. Please, Mr. How do we go about this? So I will answer assuming that the child is under the age of 18 years. So if you are here and you have got a British citizen, um, and your ex has got indefinite leave to remain, either of you, if you're the parents of the children, both of you, if you're the parents of the children, either of you can make the application to bring the child over to the United Kingdom. Since both of you have got, okay, one of you has got British citizenship and your ex has got indefinite leave to remain, whoever decides to make the application to bring over the children must be earning at least 18,600 per annum gross salary, and you can prove that by producing at least 6 months bank statements, 6 months pay slips, and a letter from your employer, and the usual evidence to prove your relationship, and the evidence to prove that you've got accommodation, the communication that you have, if the child is in school, letters from schools, or the doctors, the dentist, and so forth. So you can make an application to bring over the child. Um, on average, the application fee is charged in local currencies, but on average is around 1,500, 1,600 pounds, depending on the exchange rate. And the child may also be required to pay the insurance or the surcharge, which is £1,560. And if you are using a legal representative, they might charge you a fee for their services. If the child is over 18 years, um, that child is now an adult in his or her own right, so they cannot come to join the family under the usual family rules. They can come maybe to visit as a visitor, or if you've got the resources, they can come and invest in a business startup, things like that, or they can come and study to go to university. If they come to study, um, it is also important to know that after they finish their course, the post-study graduate visa is now back. They can get an additional 2 years to get work experience in the United Kingdom after they finish their studies. So they can have their 3 years in university, for example, and then an additional 2 years on post-study, and then they've accrued about 5 years. And I'm sure within those 5 years, they can be able to get some other means of trying to secure long-term their stay in the United Kingdom. If that child has start, or if that person who is now an adult and is a child have started their own family, then they can maybe rely on family grounds or another grounds that might be established at the time. And if they are working on a job that is on the job shortage list, then they can be sponsored by an employer with a sponsor license to work here in the United Kingdom under what was called the Tier 2, but not the skilled worker visa. What if I have someone to adopt my child? Adoption is not an easy process. That's what I can say to you. It's not an easy process, and the person to adopt that person might have to travel to the country where that child is, and then there's the involvement of the social services and a number of authorities and so forth for them to come to a conclusion that that child can be adopted. But if you get someone to adopt your child, if you're successful, then the adoptive parent can make an application to come to bring the child to the United Kingdom as their own child. They will be considered as part of the family of the adoptive parent. As an alternative to adoption, you might consider a guardianship order where someone becomes a legal guardian of the child. And we've made some applications using a guardianship order, which some have been successful, some have been challenged, but it's a possible way that you can do as well. I got offered leave to remain 2 years ago, so it expires next month in May on this 21st. So I want to extend. I got offered on the basis of family life, so I need the steps and the forms that I need to fill. Um, so basically, if you are on this type of visa, which you have been given 2.5 years, which you have to renew, you will need to show that the circumstances are still there, which you were granted the visa. If it was on the basis of family, you need to prove that there is family life that is in existence. And forms are no longer being used at the moment. Applications start online, so if you've got the capacity and the know-how to go to navigate through the vast information from the Home Office on the gov.uk website, you can go on there and start the application. If you require our services at Tanlo Solicitors, we can help you to make an application for your 2.5 years, which you have to renew under normal circumstances until you accrue 10 years, and then after the 10 years, you get your indefinite leave to remain. So there's no forms to fill, or everything is done online, and you have to continue to prove that if it was family life, then family life is still in existence. If you require our services, you can contact me privately, and we can then deal with you on that basis, bearing in mind that for our services, unless if the case qualifies for legal aid, which we do have a contract, we do charge a fee for all private matters that are not covered under legal aid. One important point that I want to remind our viewers is that if you are in the United Kingdom on the basis of being an EU a citizen, or being an EU citizen dependent, you need to make sure that you beat the deadline to get your pre-settlement or your settled status before the 31st of July of June. From the 1st of July, if you don't have your pre-settled status or your settled status, you might become an overstayer. So make sure that you apply for your pre-settled status or your settled status before the deadline, which is the 31st of June. Time moves very fast. We are nearly coming to the end of the month of April, so that just gives you maybe 2 months or so to take action. The process is done online, and if the Home Office requires further evidence or information, they can then contact you and request more information. If they get your national insurance number, they normally deal with it without necessarily getting more information from you, because they can get as much information as they can using your national insurance number. We do not have an office in Manchester. Our office is based in Coventry, but for the past 12 to 14 months, we have been dealing with clients remotely. Our consultations are done either over the phone, or we have got Zoom, or we can do Microsoft Teams or WhatsApp videos. So it can be telephone or by way of video. So, and then you can email us any documents or post us any documents that are relevant. So distance really is not something that can stop you from instructing us. We've got clients that are all over the world. We get instructed from different parts of the world for people who want to come and uh, to come to the United Kingdom under entry clearance, and they just instruct us remotely from America. We've got clients in America, in Africa, in Asia, Australia, and so forth. So you can do that, and then we can be able to help you. Um, I need a refund. I'm a health worker and paid the IHS. Is that possible? There's an email which you can send an email to the Home Office about a refund for IHS. I'm not so sure if so many people have been successful in getting any refunds from them, but the government, I think, in my view, had promised that anyone who works in the health and social care would get some kind of exemption in terms of the IHS. That has not really fully materialized. Those who have benefited are the ones who are coming on tier 2 visa, who are coming being sponsored by employers. We have got a skilled worker sponsor license or a tier 2 sponsor license. Those ones are exempt from IHS automatically, and their fee that they are paying is quite reduced. It is off my head around £550, I think. Whilst under normal circumstances, people pay a fee of about £1,033 to get a visa application done processed by the Home Office, and in addition that they pay in HS of £1,560, and then biometric enrollment of £19.20, and so forth. So there is an email online. I don't have it with me, but you could search on the gov.uk website and to get the email. To some of my viewers who are in business and who have been applying for sponsor licenses, and we have got sponsor licenses, the Home Office has now resumed inspections for your premises or your systems for under the normal sponsor license inspections which they normally do, so that you can get a visit, whether announced or unannounced, from the Home Office in relation to your sponsor license, especially if they suspect that something is not right. So expect the visits. They've now started. They will obviously ask you questions to see if your premises are COVID-19 compliant and so forth. But expect some visits if you've got a sponsor license. At Tanlo Solicitors, we can help you to do mock visits, mock inspections, to just stress test your systems. So if you want help in that regard, you can contact me and we should be able to help you with mock inspections. Can one apply for an EU scheme if your stay is near end? If you have got an EU relative whom you are dependent on, or if you are an EU dependent or EU person yourself, then the EU scheme is for you. If you are not in that category, the EU scheme is not for you. So you have to know whether or not you fall in that category. And if you try to make an application where you do not qualify and your visa is then rejected and so forth, you are complicating your immigration history, and you might end up overstaying if, for example, you do not submit another application within 14 days of the rejection and so forth. So you might end up affecting your chances of getting indefinite leave to remain, for example, on the basis of long stay or in other reason, because you deviate, breached immigration rules. So if you qualify for the EU scheme, and that is a big if, then you can make an application for an EU scheme. You don't have to wait until your visa is coming to an end. Like I said, this scheme has got a deadline of the 31st of June. So you have to make your application even if your visa is still has got a lot of life left in it. You still have to make the application before the 31st of June so that you do not lose on this EU scheme. My 3-year son was granted family reunion visa, but it is stated work permitted. Will he be entitled to child tax credits? That is also dependent on the conditions of the visa, and maybe the child was granted the visa in line with the parents. What is the visa that the parent has, because the child is a dependent of the parent? What is the parent visa saying? So it will depend on that as well. Otherwise, you might breach claiming public funds when you are not entitled to claim public funds. So I think for that question, um, after the show or tomorrow morning, particularly tomorrow morning, because it's 6:30 p.m. in the United Kingdom, I will not be able to take any calls tonight, but tomorrow I'll be able to take calls. You can contact me or email me on the email on the screen, and I'll be able to answer those particular questions or deal with your case and suggest any solutions that might be available so that we can be able to assist you. So email me the visa for yourself and your son or your family and the decision letters, and then I can scrutinize your case and give you adequate advice subject to what I think professionally about it. I have my brother who needs to apply for support worker under tier 2. How do I get started? And I need help, please. I've got a lot of inquiries that I'm getting for this support worker auxiliary nurse visa, and I've had a presentation on Zimbo Life before about this. And as a disclaimer, Tanlo Solicitors is not an employer in the healthcare or social care sector. We are solicitors or lawyers who help people make visa applications under the circumstances or we help with employment law. So we get instructed by people who want to apply for a sponsor license to get a sponsor license, and we also advise employers and employees on employment matters. Where someone has been offered a job offer with a tier 2 sponsor, then if they want, they can come to us and we can help them do a visa application. But by and large, and in summary, if someone wants to come to work in the United Kingdom as a support worker, point number one, they have to do a job application. So they have to submit their CV to a company that has got a tier 2 sponsor license, and there's a sponsor license register that is available online. If you just um, put in sponsor license register, you will see it. It runs into thousands of pages. People will charge you, or consultants will charge you if you want them to glean through those sponsor license register to give you the relevant information, which is something we can do, but we'll do it for a fee. When they submit their CV to the company, it's then up to the company to shortlist them for an interview. They will attend an interview, and then they will be, if they are offered a job, the next stage is the company will generate a sponsor certificate, and then we make the visa application. So most recruiters that I've spoken with, um, although there is no formal qualifications for this particular type of visa, they do have their own minimum qualifications that they expect, and they do have their own minimum experience which they expect. Remember, once you've got a sponsor license, as I was saying before, the Home Office can come and visit you and check on what you are doing and how you are doing it. If you want to maintain your sponsor license and probably keep your business in good order, then you need to comply with the sponsor license. So they might employ people who have got qualifications and mandatory training, which is relevant to the job and maybe relevant experience. So if your brother has got some qualification in the healthcare, or even if they don't have, it's up to the employers. I'm not an employer in that regard. Then they might be able to uh, apply for the job. For more information on this, go on our website www.tanlaw.co.uk, or another website that we have, which I'm tapping now, which I've put um, some blogs about this on these websites, so you can um, check for more information on the blogs that I have done on the support worker visa in the United Kingdom. What is IHS? IHS means Insurance Health Surcharge. This is a tax that was introduced by the government uh, so that people who do not have indefinite leave to remain or a British citizen, or who were at the time not EU citizens, you have to pay to the government to be allowed to use the NHS. So it's a tax for people who are on limited leave to remain to um, use the NHS, and it is a requirement under those circumstances to be paid to the Home Office, and that will allow you to use the NHS for 2.5 years, and then when you make your application again, when you extend, you pay it again and again and again until you get your 10 years, and then after that, after indefinite leave to remain, you do not have to pay the IHS. I have a friend who has been in the UK for more than 20 years, applies for asylum which have been refused. What should she do? She's a qualified nurse. Okay, if the person has been in the United Kingdom for more than 20 years, we will need evidence to prove that they have been in the United Kingdom for 20 years or more. And on that basis, particularly if they do not have any criminal convictions, we should be able to help them get a visa or leave to remain on the basis of private life in the United Kingdom under immigration. What is it now? It just went off my head now. Uh, ADE, is it 217 ADE or something like that? Um, So we should be able to help them for private life for 20 years. We can show the stamp in the passport, and if the copy of the passport is with the Home Office, then we can do a subject access request with the Home Office and request your file from the Home Office, check what is in there. If that person has done different things in the United Kingdom, such as being a student or working or volunteering, getting medical help, going to church or a mosque, and so forth. We can gather all that information, compile a bundle of the evidence, and submit to the Home Office. On that basis alone, she can be able to get a visa. If she's a qualified nurse, then that's another thing on its own. She can then maybe need to start the process of registering with the regulatory body, doing all the relevant exams that might need to be done, and then ultimately practice as a nurse if she is given the pin to do so. As for the asylum matter, asylum if your asylum has been refused, you can try what is called a fresh claim or further submissions if you have got new evidence or better evidence or evidence that was not in existence at the time when you made your application. So, for example, if your asylum was on political grounds and you didn't have a warrant of arrest, which is critical to your case, and you have not secured the warrant of arrest, then you can use that as a ground to make a fresh claim. Or if the situation in your home country gets worse, then you can use that. Um, if you are not married and you are married, if you didn't have children and you now have children, or you've got a serious medical condition and so forth, you can make an application on the basis of that under what is called a fresh claim or further submissions. So for your friend, the two options are either to make an application on private life 20 years and above, or to do a fresh claim. If the evidence is good for the 20 years, I wouldn't bother myself with a fresh claim. I would just advise the client to go for the 20 years. There is a fee applicable, of course, £1,033 for the Home Office fee, £1,560 for the IHS, and the legal representative fee if they are going to go through a legal representative. Someone is asking about the scheme. We were speaking about the EU scheme that since Brexit, the United Kingdom has left EU. So since Brexit, there is a concession, if I can put it that way, that all the EU citizens in the United Kingdom can apply for what is called pre-settled status or settled status, and the deadline to do so is the 31st of June. So if you do not do it by then, you might risk becoming an overstayer in the United Kingdom. It's a free application. It's done online. I don't think there's any reason why someone should not do it if they want to remain in the United Kingdom as an EU citizen who should have leave to remain in the United Kingdom. If the person has yet stayed in the United Kingdom for over 5 years, they will get their settled status. If they've been in the United Kingdom for less than 5 years, then they'll get their pre-settled status, and then they have to do the 5 years and then get their settled status. Sarah, if you're saying the parent has got settled status, I think that's the question about a child who got given 3 years. So if the child has got indefinite leave to remain, settled status, yes, the child will be entitled to the benefits because the parent is a settled person. IHS, if someone is on a tier 2 sponsor license in the health and social care sector, they are currently not paying IHS if they're on that. But some who are in the healthcare sector and you've got a different type of visa, for example, you've got a human rights visa, a 2.5 years visa, or you've got whether discretionary or a family, or you might be you're still susceptible to paying the IHS, and there's an email there where you can apply for a refund. For that, whether it will be successful or not is another question. But it was my understanding, and it was almost a blanket understanding of people, that anyone in the healthcare sector will be exempt, but it looks like it's not the current situation as it stands. When you make the application, you will be required to make the fee, to pay the fee, and then maybe you can then maybe try to claim it back from the government. And the person asking, what about for South Africa? Can you please clarify your question so that I can understand? I'm just checking through our questions again so that I can see if I've missed anything. And if you've got any questions, you can ask me as I'm checking. Okay, the other question is, how do you deal with reinstating indefinite leave to remain? That will depend on the reason why the indefinite leave to remain was revoked. I would want to think that the indefinite leave to remain was revoked because maybe someone committed a criminal offense, and since they committed a criminal offense, it might have been, instead of being deported, that person had their indefinite leave to remain revoked. So it's two things. It can be revoked and they take it and they deport you, or they make a deportation order to deport you, or they can revoke the indefinite leave to remain and replace it with limited leave to remain, whereby they might give you 6 months to renew every 6 months, or they might give you 2.5 years or 3 years. Now, depending on the criminal conviction, if the criminal conviction, for example, is less than 3 years or between a year and 4 years, and then if the criminal conviction is over 4 years, then you might, if they've put you on limited leave to remain, then you will not get your indefinite leave to remain for 15 years. So you have to wait for 15 years so that you can get your indefinite leave to remain. So there's a graduated period which is applicable to different periods of convictions or a sentencing that has been given. So for less than 12 months, I think it's 3 years, and then for 12 months to 4 years, it should be in between, and then for over 4 years, it's 15 years, something like that. So um, that is also subject to maybe me checking your circumstances and then advising accordingly. I do not see any other reason why they can just revoke it, maybe unless if there is elements of or also deceit where you lied to the Home Office or maybe claimed to be someone else who you are not, or your circumstances have been proved to be incorrect by the Home Office. So again, under those circumstances, if you've got, for example, family, we can then make an application on the basis of family or a private life if you've been in the country for more than 20 years and so forth. So there might be other various ways to try to redress the situation, but each case depends upon its own facts. Okay. Can someone whose leave to remain was revoked due to a criminal offense apply to come back if over 18, but or their family settled in the United Kingdom? Where you where the leave to remain was revoked due to a criminal conviction, again would depend on the circumstances, like I was saying earlier on. Um, if you've got family, have you been rehabilitated? What evidence do you have? Are you a low risk? Are you high risk? What sort of criminal conviction was it? If you were deported out of the country, or if you left the country, was it on your own expense? Were you forcibly removed? Was it voluntary leaving of the country, and so forth? So that depends on the facts of the case. So it will not always be that because the family is settled in the UK, then you should be able to come back if your leave to remain was revoked due to a criminal conviction, and it will also depend on the seriousness of the criminal conviction. If it's not a serious conviction or a criminal offense, then if you someone who is a habitual or a prolific offender, then they might also consider that. So again, representations need to be made to the Home Office according to your circumstances, and try to persuade the Home Office. Where in this case there is family, then we need to produce, for example, social worker reports, your criminal psychologist reports, and family life letters from the GP, and so forth to show that the quality of life for the children and for the family is affected by your absence, and family life is also affected. Remember, it should be disproportionately affected, because if it is proportionate, then that will not really matter to the Home Office. So we need to prove how the family life is disproportionately affected, trying to do a balancing exercise against family life against public interest. Someone says I've got a guardianship for my 22-year-old nephew, um, who is living with my elderly parents, is it possible for me to apply for the visit? Since it's over 22 years now, you will not necessarily have guardianship. They are an adult now, unless if they've got mental health issues and they cannot care for themselves. But nonetheless, if you mean that you've got a responsibility because maybe they are not working in wherever they are staying, and you are kind of financially responsible for them, then you can make an application for them to come to the United Kingdom as a visitor, or maybe as a student, or if they get employment as a sponsored employee. The requirements of a visitor, the main challenge that people face is coming from countries and which are considered by the Home Office unofficially, but that's their view, poor countries, is that they might not want to return when they come to the United Kingdom. That is the reason why most applications are refused, that you have not proven that you've got intention to return, because you've not shown that you are working, or you've got resources, or you've got any other things that I've termed pull factors. So if your 22-year-old nephew is not working, does not have a business, does not have resources, you might want to think of how ways of addressing that before you can make an application to come to the United Kingdom. Otherwise, 9 out of 10 times that application might be refused. But you can still try, and with like someone can still be successful. So yeah, there's nothing to stop you from making an application for him to visit you in the United Kingdom, producing all the relevant information. Can someone with uh, social worker degree from Zambia or Zimbabwe come and work in the United Kingdom? The social work is on the job shortage list. So yes, they can come and work to the United Kingdom, provided that they've got a sponsor, an employer who has offered them a job and they've given them a sponsor certificate, and then on that basis they can make an application to come to and work in the United Kingdom. But on the face of it, yes, they can be able to do it. The process is that they have to make a job application like anyone else, submit their CVs, go through the interview process, meet the Home Office requirements, some of which are passing the IELTS test, and making sure that they've got the maintenance money, unless if their sponsor is rated A, and things like not having a criminal conviction, getting a police clearance from the country which they have been, the countries that they have stayed for more than 12 months, and so forth. So if they meet the immigration rules and the employer is happy with them, potentially they can come and work in the United Kingdom. Can I apply for a child who was born in England but raised in Zimbabwe? What kind of application do I do? This child is 19. The child is now an adult. So that's an adult application that you need to make. It could be a visitor's visa. It could maybe um, student visa, employment visa, and so forth. If the child was born in England, uh, I want to know maybe the circumstances of the parents. What visa did the parents have? Were they British and so forth? Maybe that person can be British, and I'm not so sure from the question. But from their age, and they are now 19, so they are an adult. So it's an adult application that needs to be made. What are the routes available for overstayers to regulate their stay? No criminal conviction, less than 20 years. Under those circumstances, you might consider the major one that people make when they've got less than 20 years and they're overstayers is maybe if they've made an application for asylum which was rejected, they might consider submitting a fresh claim or further submissions. If there's a change in their circumstances or in the if they've got additional new evidence which was not in existence at the time when they were rejected. So you have to look at your case if you've got new evidence. Sometimes there is a new country guidance case. You are now involved politically if you were not, or you've got a political position. The situation in your home country have got worse. You now have family if you didn't have family and so forth. The main one which people use, I think, is family life. If that person is now married, and I get asked by people, can an overstayer get married? Yes, an overstayer can get married to someone who has got leave to remain or a British citizen in the United Kingdom. If the oversteer doesn't have their passport and their copies with the Home Office, you can still contact the registrar so that you can register your marriage. The registrar will refer you to the Home Office. The Home Office and the registrar will communicate. Normally, they might give you an email whereby they communicate, and then the Home Office will confirm your identification to the registrar. It's now to the Home Office whether to allow you to get married on the 21 days notice, or they will extend the notice to 70 days and investigate your case. And maybe they might say, come for an interview in Liverpool. They'll ask you questions to try to prove that you are a genuine and subsisting relationship. They ask you questions which a partner is supposed to know about their partner. So that's the main route which people with got 20 years in no criminal convictions use. It's either they get married or even unmarried partner, and also they've got children and so forth. So then, depending on the circumstances, they can make an application on that basis. Where they've got a family in this country, the option preferred by the Home Office is always that you have to leave the UK and make an entry clearance application, but you have to prove that you meet all the requirements, and it's not really necessary for you to travel outside the country to just make a visa application. So, um, you know, things that we call, or we used to call, Chikwamba principle and so forth, but they would want you to leave the country. But some people are afraid to leave the country because they think that because they've overstayed, if they leave the country, they cannot come back. But we've got clients that have left the country and they've been able to come back, even if they were overstayers. Okay. Can I apply for a visitor's visa for my mother? I work part time as a job youth. Yes, potentially you can apply for a visitor's visa for your mom, for anyone for that matter. You do the invitation letter, and then they have to submit evidence that they've got intention to return to their home country, that you are able to look after them, or they are able to support themselves in the United Kingdom, there's sufficient accommodation, and so forth. So you should be able to apply for them. But like I said earlier on, the main reason why the Home Office refuse, especially to younger generation people, is that they think that because people are coming from a poorer background, in my view, then if they come to the United Kingdom, they will not go back. So they will say that you have not proved your intention to return back to your home country because you have not shown that you are working, or you have not given us your bank statements, or you have not seen your assets, and so forth. So you need to prove that you've got assets, maybe you've got a family link back home, you are working and the employer has given you a letter confirming that you are on leave or a holiday. If you're at university, you've got a letter from your university and so forth. If your mother is on pension, then it may be a pension letter and so forth. So you can invite your mother. On 10 years route, fees are expensive to renew for 4 people with one child turning 10 soon after being born in the United Kingdom. Is it possible not to include him on the renewal, then put separate application when it turns 10? If you've got no intentions of traveling anytime soon and the child is turning 10 soon, then yes, you can potentially leave them out on this application. And then when they turn 10, you can then make an application to naturalize them as a British citizen. As long as you're not you've got intentions, and I think most people don't have intentions to travel unless it's an emergency due to the COVID-19 situation worldwide at the moment. If you are struggling to pay for your fees, particularly when if it's linked to COVID-19, you can make an application for what is called a fee waiver. The Home Office has been on understanding terms with regards to fee waivers. Show them that you cannot pay for the fees, and you have not been working, you've been on furlough, you're working part time, this and that, and so forth. They will want to see your bank statements, your financial information, they will do some credit checks and so forth. Lucky on your side, you get a fee waiver and you don't have to pay a penny. If not that, then you pay and maybe exclude the child who's about to 1010 to try to cut your costs. I'll just answer just 2 or 3 questions more and then I'll wind up. Both parents were not British at the time he was born, but I am British now. I think it might be linked to an earlier question, which I cannot catch up with now. Why is it years for biometric? I'm not so sure why years on a biometric were reduced from 10 years to 4 years. I don't think they're going to reduce to 4 years. I cannot really answer that question, Martin. Anyway, but I don't think biometrics were from 10 years before. They used to give them either 5 years or 3 years and so forth. But the 10 years is the 10-year route where you get 2.5 years. If I've misunderstood your question, please email me or WhatsApp me so that I can answer you directly on that question, Tandiwe, so that I can understand it. If I've misunderstood any questions, guys, just contact me so that I'll be able to clarify to you individually. We are not a recruiting agents. Like I said, we don't have any agents recruiting. We are just legal practitioners. We are lawyers, so we don't have people recruiting anywhere. But we do offer advice. I am British. How can my Jamaican parents come to the UK permanently? They are 60 and 83. 60 and 63. There's a route which is called the adult dependent relative. If they can show that they cannot do personal care by themselves, then it could be something potentially available to them. But again, you might need to explain to me your circumstances, and so that I'll be able um, to help you if you contact me. But if it's just a general one, then the other dependent relative, which is a bit difficult for many people to try to apply for because of the um, stringent requirements of the Home Office. Is there a visa I can apply for my mom or father to come stay with me long term as my dependent if I'm on an European passport holder and my parents have got African passports? Again, it's the adult dependent relative visa that you can try to apply for. Um, the EU at the moment until 31, we are in the transitional period. So they seem to have until the transitional period and ease away with the Home Office. So it's the adult dependent um, visa that you can apply for. Um, if not, then you can just have to try to apply for the 10-year visitors route visa. I'll answer one question and then I go because of our time. How long does it take to file divorce in Zimbabwe if the other parent is in South Africa? My sister tried it and then the mother of the man returned the letters. Okay, so that is quite a difficult situation when people are in different jurisdictions and trying to file papers and so forth, and then trying to get into another jurisdiction. You have that order um, filed in another jurisdiction and so forth. Um, I wouldn't know necessarily with the COVID-19 delays that are there how long it takes, but most things are facing delays because of COVID-19. So if you are filing the divorce, I would say maybe expect some delay of some sort, particularly if it's a case where there is two people in two different jurisdictions. Is one might be on lockdown, one might not be on lockdown, and things like that, and different conditions. So it's quite difficult to give a time scale. I would like to thank you all for attending this meeting today. And if you want to contact me, my details are on the screen. You can send a WhatsApp message, you can email me, or you can go on our website through the contact us page and contact us. Until next week, thank you so much for being with me today. Thanks. My name is Andrew from Tanlaw.